So good morning. This is Dixie. I am Dixie Newnham. I am with Newnham Land, and I am today presenting on things that can help you as you age, basically ancillary documents. And so, as you all know, this is for educational purposes. Nothing in here is intended to be legal advice. If you have any questions about your specific circumstances, make sure to check with an estate planning attorney. There's lots of us here in the state of Texas that can help you out. But otherwise, I'm hoping that some of this information today will help you understand some of the things that are helpful as you age. So quickly, just doing a review of some of the things that we looked at before. The reason I'm doing this in particular with this presentation is that some of the concepts that we're going to talk about today build off of or incorporate some of the stuff that we talked about previously. So I just wanted to give you a quick overview on where we've been. And if you were wanting to brush up or look back, these presentations are on the YouTube channel associated with the library. And so you can go back and look at those if you want to. And so the first presentation we did was on wills. We talked about some do's and don'ts for wills, some basic provisions, dangers of dated or do-it-yourself wills, and generally why everyone needs one. We then, in our second talk, talked about trusts and what a trust is and when you might want one. In particular, we talked about how trusts can help you when you're aging. And so that's something we touched on. I didn't go too far in depth at that point because there was a lot of other ground to cover. And really the focus of that presentation was on how trusts can facilitate estate planning, or basically what happens when you are deceased. And so we're going to go a little more into depth into trusts today and how that can affect you while you're aging. And then the third presentation that I did was on joint ownership and beneficiary designations, basically discussing what those are and how they work. And again, that focus was on how those assets can pass upon your demise. And so today we're going to talk about ancillary documents and aging. So ancillary documents are things like financial powers of attorney, medical powers of attorney. And so you'll see that we are going to focus on those two areas today, the financial and the medical. And under the financial, we'll talk about powers of attorneys, trusts, co-ownerships, and convenience accounts. And then under the medical side, we're going to talk about powers of attorney, living wills, and HIPAA releases. And so these ancillary documents are things that you often talk about with an attorney when you're doing an estate plan, but can also be things that you put in place without a will. So let's talk a little bit about that difference, right? So some of our previous topics on wills, trusts, and beneficiary designations really focused on what happens once you are deceased. How do your assets pass from you to your loved ones? Today's topics shift, and today's topics really talk about a period when you were alive. So how can these documents help you while you are still alive? And that's what makes them different from a will. A will only comes into effect once you have passed. These documents that we're talking about today come into effect while you are still alive. So you may be asking yourself, why would I need these documents, right? Why might I want ancillary documents to help me while I'm alive? And the big answer really is aging. That's usually the biggest reason people want ancillary documents. They are getting older and they want some help managing their finances and or medical situations. However, it does not have to be just for someone who's aging. Oftentimes these documents are very helpful if you have a degenerative disease such as dementia or maybe Parkinson's that makes it difficult for you to manage your affairs on your own. Or if you're really proactive and you're younger and you have these documents and later develop a disability, then these can help your loved ones manage your affairs for you if you are unable to do so. So I don't want to get stuck too much on the term aging, although that is usually where we see these documents come into play, because it can really be helpful for younger people as well. And I think too few younger people actually have these documents. But really, the biggest area where you see them is where someone is getting older and needs a little bit of help just managing their day-to-day affairs. So that's when you would want them. So let's start on the financial side, and let's start with the durable power of attorney, because I think this is the most common one that people have either heard of or possibly even have done for themselves. So what is a durable power of attorney? This is a power of attorney that authorizes someone to act on your behalf as to financial matters. So you are choosing an agent. Okay, so a couple of terms to know: principal and agent. And the agent is the person that you are authorizing to take action on your behalf. So when you think, if you're kind of wondering agent, not really sure how that term works, think of a real estate agent. When you hire a real estate agent, you hire that person to go out, help you find a house, negotiate the deal, and help you close. And so by doing that, excuse me, sorry, let me get that off the screen and go back for a second. In doing that, you have hired a real estate agent to act on your behalf as to real estate matters. So you can think of this agent as the agent who's going to act for you on financial matters, right? They're going to be able to manage things like bank accounts and other assets that you might have. So they are your agent. Typically, you are the principal, but the principal is really anyone who signs a power of attorney. Sometimes you might be an agent for someone as well. So we'll talk a little bit more as we go through this on what the principal is doing and what the agent is doing. But I don't want you to get caught up on those terms. Just know that the principal is the person who's authorizing someone to act on their behalf, and the agent is the person who's acting on that authorization. So this is a form power of attorney promulgated by the state of Texas. Each state has their own form power of attorneys, or at least let me put it this way. Most states I'm familiar with have their own power of attorney. There may be some that don't. Typically, and different states have different rules regarding powers of attorney. So you do not have to use most states' forms, although they have them. However, I will tell you there is some benefit in using the state forms. And it is this: institutions within the state of Texas are most familiar with the state form. When they are handed a power of attorney that is not the Texas state form, sometimes that will flummox them and make it harder to use that power of attorney with that institution. And that can become problematic. So let's take an instance where, let's say you have signed a power of attorney, you're aging, and you've signed a power of attorney in favor of a son or a daughter. And your son or daughter goes to the bank to transact business for you, but they have a different form other than the Texas state form. The bank may say, no, we don't like this form. We're not comfortable with this form. It doesn't meet some guideline under Texas law. And so they won't allow your son or daughter to transact business. And you may or may not have capacity at that point to sign a new one. Capacity is the ability to understand what you are doing. So you can imagine someone who has dementia at some point is unable to sign a power of attorney or a new one because they can no longer really understand what they're signing or why. And so it is very helpful to use the state forms for the state that you are in. One of the drawbacks with that is if you have to transact business in another state, oftentimes the other states don't want to use another state's form. So for example, in Florida has some very specific provisions on how their powers of attorney need to be signed if you are selling a residential piece of property. And the Texas form may or may not accomplish that. So you may end up having to sign a second power of attorney to transact business in another state. And again, as we just discussed, that can be problematic if you no longer have capacity. So That's a very complicated way of saying the state forms are probably the best way to go for the state that you are living in, but understand that there are some drawbacks to that, and there may be circumstances where you want to do something a little bit different. So, like I said, this is the Texas state form, and I'm going to dig into a few of these provisions because being in the state of Texas, if you were looking at doing a power of attorney, this is more than likely what you would look at signing. So up front, the Texas durable power of attorney has in here that it is broad and sweeping. You will see at the very top those terms. The powers granted in this document are broad and sweeping. There's a reason why that is in all caps in the first words on this form. Powers of attorney, when you give them to someone, give them a lot of authority to be able to do things on your behalf. That can become problematic if the person you choose is not trustworthy. So unfortunately, with powers of attorney, you also can see a lot of elder abuse, meaning a principal may give someone the authority to act on their behalf under a power of attorney, and that person may actually steal from the principal because of that power of attorney. Now, there are some safeguards, and a little later on, we're going to talk about the agent's duties to the person who's authorized them to act on their behalf. But just know that there can be problems with the durable power of attorney. And so when you're choosing who you want as your power of attorney, you really need to give thought to who you trust and who you think is stable in their life circumstances. So the second point that's up front here that I want to point out is this document does not authorize anyone to make medical or healthcare decisions for you. And it is often a good idea to have your medical power of attorney be a separate document than your financial power of attorney. The reason for that is the person who's acting on your medical behalf may not be the same person you want acting on your financial behalf. I know a lot of people who say, oh, I have this person in my life who's great with numbers. That's absolutely who I want, handling my bank accounts. But they're not as touchy-feely as maybe this person over here who is maybe a little better at tending to emotional needs. And that's really the person I want acting on my medical behalf. So just know when you sign a statutory durable power of attorney in Texas, it does not cover your medical decisions. We'll go over medical powers of attorney here in a moment. And the reason for that is you may want two different people making those decisions. So they are usually two standalone documents. Also, the last point to make here, Texas also has, because of its homestead exemptions, it has some specific laws regarding equity loans. So think of loans that you may take out on your house to pull out the equity. And if you want your agent to be able to do equity loans, the power of attorney must be signed in a specific location, including a lender's office or an attorney's office or a title company. So that can sort of trip things up if you're not aware of that. But that only comes into play if you're looking at signing an equity loan. So once you get past those big topics, the first thing that your power of attorney does is it appoints someone to act on your behalf. So in this power of attorney, John Doe here has appointed his wife, Jane Doe, to act as his agent. And so when you have husbands and wife, that's typically the scenario you see, is that they will first appoint their husband or wife as an agent. However, there are lots of people who aren't married, and so oftentimes they'll choose a child or maybe a brother or a sister. I've even seen friends, cousins. It really depends on who it is you're close to in your life that you trust. The second thing you will see on a Texas power of attorney are the list of powers that you can give someone. So let's talk about two different situations regarding these powers. One is a situation where you are aging and you want to give someone broad authority to help you in as many areas as possible. And so why might that be? As we talked about earlier, as you age, you may begin to lose capacity. You may begin to lose the ability to sign a new power of attorney. And if that's the case, you don't have a crystal ball and you don't know what sort of transactions your power of attorney may need to take on your behalf in the future. So oftentimes when powers of attorney are signed for that purpose, to give someone authority to help you as you age, usually people will initial O, that last category at the bottom, giving their agent the ability to handle all those matters listed there. Real property transactions. Real property transactions are houses, real estate, land, condos, mineral rights, even timeshares. Tangible personal property, that's your belongings for the most part. Stocks and bonds transactions, commodities, banking, that's a big one. Business operating transactions, that's typically if you own an interest in an LLC or some other entity partnership, those sort of things. Insurance and annuity transactions, estate trust and other beneficiary transactions. I want to point that one out specifically. That does not mean that your agent can change your estate plan, your trust, or your beneficiary transactions. To the contrary, that actually means if you are a beneficiary for an estate, a trust, or something like that, then your power of attorney can, or your agent can manage those affairs for you. They cannot change your estate plan by initialing that one. Claims and litigation, if you're in a lawsuit, giving them the ability to handle that. Personal and family maintenance, so that is, taking care of your day-to-day needs, living expenses, food, utilities, those sort of things. That they can handle your benefits from Social Security, Medicare, Medicaid, make sure you're getting those things. Retirement plan transactions. So if you have a 401k, they can make sure that you're taking your required minimum distributions if you're at that age. They can handle tax matters. They can file your tax returns for you. Important if you still have income and are unable to do those on your own. And then digital assets, that is the biggie these days. Most people are now doing their transactions online, banking, financial institutions, those sort of things, even handling health insurance online. In particular, COVID, that has grown tremendously. Many more people are doing their day-to-day affairs online. And then also you have your email account, your Facebook account, your Instagram account, all of those things that you may want someone to be able to get in and manage for you if you're unable to do so. So you can see that if you're signing this for a reason like aging, you may want to give someone all those powers, more than likely would, because you don't really know which ones they might need in the future. Now, there is a second instance where you may want to use this form that's more specific. So let me give an example that I've seen quite a few times during my practice. You are maybe traveling for a extended period of time. Maybe you're going overseas and going on a 3-month vacation, or maybe you are someone who lives half the year in a warm climate like Texas, and then when it gets hot here in the summer, you take off somewhere cooler like Michigan. You may want at some point, while you're still perfectly capable, to do some sort of transaction that you would physically need to be in another place for. So let's take the example of the snowbird who lives in winter in Texas, summer in Michigan, but you decide that you want to sell your property here in Texas and you can't come for the closing. Then you can sign a durable power of attorney that would allow someone to sign your real estate documents on your behalf. In that instance, you may only want to give them the power to transact real property transactions. You may not want to give them A through N to transact. So these are really, while today we're focusing on the aging aspect of durable powers of attorney, just know that they are also helpful in specific circumstance transactions. The next area that I want to focus on are these extended powers. So in the Texas form, they have 5 areas, these that you see on the screen, that they specifically call out separate from those initial areas. And the reason for that is these are really powerful tools to give someone. And so Texas wants to make very, very sure that's what you want to do before you go give these to someone. So you can see the first one is create, amend, revoke, or terminate an inter vivos trust. What essentially that does is if you have a trust-based estate plan, that allows someone to come in and change it. As you can see, it's a very big power to give someone. So you may spend a lot of time and energy setting up your estate plan, and they could come in and change it around. Same with the changing rights of survivorship on a bank account. That's the third line down, or changing a beneficiary designation. That's the fourth line down. Those again can significantly change an estate plan. As we talked in our previous session, the very last one we did in December, whenever you have rights of survivorship or beneficiary designations, those assets can pass separate and different from your will. So if your agent changes those, they can change who ultimately gets your assets. The second one, make a gift. That is the ability for your agent to take your assets and give them to someone else. Now, there are some limits set out by statute in how they can do that. But again, that's a powerful tool to give someone to be able to do that. And then the last is to authorize another person to be able to choose another person to act as your agent. So that final one would allow your agent to pick a new agent, basically. Now, these are very broad. And there are circumstances where you may want to give these. In particular, if you have a dementia diagnosis, some of these could be helpful because your spouse may need to do some sort of extended planning for you, like Medicaid planning, at which point this could be really important. Or one or more of these. Or maybe again, you have dementia and your kids are trying to get your stuff in order in the easiest way possible. Creating a trust can be a very valuable and beneficial tool. And so at that point, you may want to give them that power. But those in particular, those 5 powers there are something that I highly recommend you discuss with an attorney regarding your specific circumstance before you give them to someone, because those really are powerful tools that can wreak a lot of havoc if they're in the wrong hands, and can change what ultimately happens with how you've set up your estate. So we've talked through the powers that you can give your financial agent. Let's talk a little bit about when this power of attorney becomes effective. So there are 2 times the power of attorney can become effective. 1, it can be effective immediately, or 2, it can be effective upon your disability. Okay, so you may think initially, wow, who would ever want it effective immediately, given the concerns about elder abuse or someone overusing their authority under here, right? Well, I'm just going to make it effective only if I'm disabled. Here is the problem in doing that. The minute you sign that your power of attorney is only effective upon your disability, then for your agent to be able to use your power of attorney, they have to prove to the institution they're using it with that you are disabled. So let's take an example. Let's say you are starting to become disabled, right? Maybe you have a dementia diagnosis, but you are still able to manage some of your affairs, right? But you really want your child helping you because you're like, I can manage them, but I'm a little iffy. I'm a little nervous about this. I really want my kids' help. So your child, son, daughter takes the power of attorney to a bank, and you have it set up that is only effective upon your disability. Well, the bank is going to say, I can't do anything unless I have proof that mom is actually disabled or dad. So then you have to go back to a doctor and get a doctor to sign a letter that says, yeah, mom or dad's disabled. Well, lots of doctors are reluctant to do that because they know, and they too are concerned about elder abuse, right? So they want to be really careful about signing letters that say mom or dad is disabled. And so lots of issues come up. One, sometimes hard to get a doctor to give you such a letter. And then two, depending how they phrase it, sometimes the bank doesn't like how they phrase it and still won't allow you to transact business. So it can make it very cumbersome to actually use the power of attorney if you make it only effective upon your disability. Second option is it's effective immediately. Well, if you make it effective immediately, as we've discussed, there is the potential for elder abuse. So typically what I advise clients is find the person you trust, right? Make them the power of attorney. And if you're comfortable with it, always easier to make it effective immediately, then don't necessarily give your power of attorney a copy of this, right? You can tell them, and in fact, I would tell them, you're my power of attorney. However, I'm going to keep this record in my records, and if I some point reach a point of disability, then I will give it to you, or here's where you can find it, right? And so you're not just giving it to them to use immediately, you're kind of putting a mechanism in there where it makes it a little more difficult for them to use. And so that can help some with that situation. The second option is sometimes you'll see this where someone has a spouse that they're like, oh yeah, I'm okay with this being effective immediately, but my backup, maybe they don't have any kids and they're not really, the backup, they trust them, but they're not really ready to let them have full power. Sometimes I've seen people say, okay, as to my spouse, this is effective immediately. As to my backup, it is only effective upon my disability. So you can sort of, change it depending on who is in play. And there are people that sometimes just go straight up upon disability. And frankly, those are sometimes the younger people that come in and who are proactive. So, someone in their 20s or 30s who has no sign of any sort of disability but wants to be proactive, then maybe it makes sense for them to make it just upon their disability, because really it's a fail-safe at that point. They're not really concerned about aging. So there are times when you may want to do it just strictly upon your disability. But know that that is there, because I think a lot of people sign these and think, oh, it's only effective upon my disability, but really it's effective immediately for the most part, unless you're making that conscious choice to make it upon disability. And again, something to talk to your attorney about when you're signing these. So now we're going to start talking a little more about agents. Everything we've talked about up to this point is really what the principal is looking at. Now we're going to look at more of the agent side of things. And so the first thing is, should your agent get paid for taking action on your behalf? Being an agent for someone could be super simple, right? Maybe occasionally you have to sign a check for them, or it can be super complicated. If, let's say mom has dementia, is living in a nursing home, you may be doing a lot of stuff on her behalf under a power of attorney, depending on how complicated her estate is. So it can be very time consuming and resource intensive or not. It just kind of depends on the person and their circumstance. So under your power of attorney, you can pay your agent a reasonable compensation for acting on your behalf. And that's the first line. So compensation being like an hourly wage, right? So your agent keeps track of the hours they spend, and then from your assets can pay themselves a small amount for taking action on your behalf. And the second line says, no, my agent is not entitled to compensation. I would say my experience in my practice has been most people say their agent is not entitled to compensation, but most of the people that I'm dealing with are choosing a family member to act as their agent. Most of the time when I see someone choose compensation for their agent, they're asking someone who is not a family member to help them out. And then they do feel like, yes, compensation should be given. Now note, under either scenario, whether you allow your agent to receive an hourly wage or not, your agent is always entitled to reimbursement of their reasonable expenses. So, for example, let's say your agent had to sign some documents and FedEx them to a title company in Florida. They can, from your assets, recuperate the cost of the FedEx package. So anything they spend on your behalf, they can reimburse themselves for. You know, another example might be if you're in assisted living and they go out and they buy you, you know, some groceries and some toilet paper, they can reimburse themselves for the amount they spent on your behalf. So you can always reimburse themselves for reasonable expenses. The question really is whether they get an hourly wage or not. The second issue to think about with your agents is co-agents. So again, going back to the concept of elder abuse or abuse under a power of attorney, a lot of people think, aha, I'm going to pick co-agents to act for me. And then that way they can sort of babysit each other. The problem with co-agents is if they have to act jointly, you end up in a situation, or can end up in a situation where nothing gets done and your welfare is disintegrating because of it. So that's really what this provision is meant to address. I don't think it really addresses it well. My experience with co-agents has not been great. Now, granted, that could be the nature of what I do by being an attorney. You know, co-agents are getting along, aren't showing up in my office asking for advice. It's co-agents who aren't getting along that come to my office asking for advice. But I have seen that more times than I'd like in my career, where agents aren't getting along and the principal, the person who signed the power of attorney, mom or dad, typically, is languishing in the meantime. So if you do choose co-agents, you then would initial one of these three lines. That one, your co-agents may act independently. So let's say you had two co-agents and you say, well, I'm not going to make them have to get along, but they can act independently. Well, what happens if they're at odds with each other and taking different actions from one another? That could be problematic. Second line is they must act jointly. Well, as we just discussed, that can be problematic if they're not agreeing. Or the third is a majority of co-agents must act jointly. That would be a situation where you have more than two co-agents, like you had three co-agents. I have yet to meet someone who wants to name three people as co-agents. I suppose that may happen at some point, but you know, typically my recommendation is go with the person you trust most, and then you can always make the other person a backup to them. And I promise you, if they're siblings, the backup will let their concerns known to the first one, because that's usually how it works. But someone kind of needs to be the decision maker. Usually that is a little bit better for whoever the principal is. So then this gets to that situation, successor agents. Always, always, always name a successor agent if you are doing this for purposes of aging. So what does that mean? The very first provision the second provision I showed you on this slide showed you that John Doe was naming Jane Doe, his wife, as his agent. Well, what happens if Jane Doe should become incapacitated or dies before John? He's going to need someone to be in that successor provision. So in this one, he is named daughter as successor, and then if daughter can't do it, son as successor. And this is really important because we have seen situations where someone who is incapacitated and elder has signed a power of attorney in favor of someone, and then that initial agent dies and there's no successor. And when there's no successor, then you have to go to court and get a guardianship to help that person. And that is costly and cumbersome, to say the least. So you really want to name a successor if you can. Again, sometimes there are situations where finding that backup person is really tough, but you really want to if it is at all possible. So the final point on agents here, and this is a very important one, for you not only to share with the agents that you choose, but if you are an agent for someone else. Not only is it a responsibility, but you owe a fiduciary duty to that person. And so what does that mean? That means you have to do what is in that person's best interest. And if you know what that person wants, you have to do what that person wants. Okay. So unless it's not in their interest. example, you know that mom, if maybe mom has a house here in Wimberley that has been the family house, but mom is now in assisted living and mom has decided she really wants to sign that house, right? And she's able to decide that. There's no dementia there. There's nothing else going on, but she can't, you know, signing the paperwork and working with the real estate agents is just more than what mom can handle. But you don't want to sell the house because you grew up there. You love the house. If that's what mom wants, it is your duty as her agent to take care of it for her. Now, let's switch that up a little bit and say mom is living in assisted living, or maybe let's change that a little bit, not assisted living, but a memory care unit. And she wants you to sell the family house and donate it all to a charity of her choice. But she really needs that money to pay for her assisted living. You do not have to sell the house and give it to a charity of choice because that is not in her best interest and she does not have capacity to make those decisions. So as you're acting as the agent, is very important that you are understanding, one, the person you're acting for, do they have capacity? And two, what do they want, right? As best as you can determine, how can you stay true to their wishes? So it is important that you are cognizant of those matters. And then as you are taking action on behalf of the agent, you're supposed to keep detailed records of those actions. So if anyone ever came back and asked you, you could show them the receipts. You could show them the paperwork. You can show them whatever it is, right? You need to keep detailed records for whoever you're acting as agent for. And then finally, this last one that I want to point out is liability of agent. If you violate the Durable Power of Attorney Act in Texas, you may be liable for damages. So if you go and steal all of the principal's assets and go to Vegas and gamble them away, that principal or someone acting on their behalf can come back after you for those assets. So just know that by being the agent, you have a lot of responsibility to act prudently. I think most agents do and work hard for that trust, but that is the backup provision that helps you on the back end if there is problems with your agent. Hopefully you never get there, right? Who wants to go fight their agent for any abuse? So better to pick an agent that you trust on the front end to try to avoid that situation, but just know that those provisions exist. So we're going to switch gears a little bit and we're going to talk about trusts. Now you may be asking yourself, well, we talked about trusts previously and we talked about how trusts can pass assets once someone is deceased. Why are we talking about it here? Well, trusts can be in effect not only when you die, they can also be in effect while you are alive. So there are lots of different trusts, but there are two that I want to point out real quick before we go any further. And that is a trust that's contained within a will called a testamentary trust, or a revocable living trust, which is a separate document apart from your will. Testamentary trusts are contained in your will cannot help you when you are aging. So anything that is in a will only comes into existence once you have passed. So if you want to use a trust for while you are aging, that has to be a separate standalone document that is already in existence. Okay, so that's what we're talking about here in general, are revocable living trusts. Although, again, like I said, there are multiple trusts for every reason you could possibly think of almost, but that's the one I want to focus on today. It's a revocable living trust. That's when people are doing estate planning, that's usually what they're thinking of. So a trust, again, is a fiduciary relationship, just like that agency we were talking about with the durable power of attorney, in which one party, known as the trustor, so in this instance, the trustor is similar to the principal, right? The trustor is giving authority to someone. But in this instance, the trustor is not just giving authority, it's also giving property to the trustee. The trustee is the agent, okay? And then that property is to be held for the benefit of either the trustor or a third-party beneficiary. So let's delve into that a little bit further. So there's the trustor, sometimes called the settlor. This is typically, let's start with thinking of this person as you. And the trustor gives property to the trustee. So real quick, I want to stop there and explain how that is different from a durable power of attorney. Under the durable power of attorney, you do not give the property to your agent. All of your property remains in your name, your bank account, how you have it set up, as it exists right now. When you are a trustor and you're using a trust for aging purposes, you are actually retitling your property into the name of the trust. Okay, so you're almost passing that property to the trustee. Now, the trustee doesn't own the property. Instead, it's holding it in trust for you. But the names on the accounts physically change, the names on your real property physically change to the name of the trust. Okay, so as durable power of attorney stays in your name. When you use a trust, it turns into the trust's name. And then the trustee makes distributions for the benefit of a beneficiary. So, because I like pictures and I think sometimes it tends to bring it home. They're my lovely, beautiful parents. So let's say they're the trustors and they give property to a trustee. There I am for distributions to my kids. This is typically, I think, what people think of, and this is really what we spent a lot of time exploring in the second presentation, is this scenario. Getting assets to someone who is not the initial trustor, who's not the person giving the property, right? But it does not have to be that way. And in fact, most revocable living trusts that we do start out like this. They start out that the trustors give the property to the trust, and the trustors are the trustees of their own trust. So basically what they're doing is they're saying, okay, we're going to take our property, we're going to retitle it into the trust's name. We are now the trustees of the trust. So we continue to manage that property, right? Not much changes other than now it's in the name of the trust, right? And then we can make distributions to ourselves whenever we want out of the trust, right? So not a lot changes there. And so they're going on, they're continuing to get older, life is going on. But at some point, they maybe reach a point where they're aging and they don't want to manage their assets anymore. At that point, their backup trustee, in this case, we're pretending it's me, can take over and manage those assets for them. So again, mom and dad have put the property into a trust. They haven't given it to me, although it kind of looks like that from the picture. Instead, think of me as the trustee. They've given it to the trust. I'm managing it on their behalf. And everything I do has to go to them unless the trust directs otherwise. Okay, so this is another mechanism in which you can have an agent, in this case your trustee, manage your financial affairs for you as you age. So what does that look like in the document? And how is the document a little bit different than the durable power of attorney? So instead of having a list of transactions like we did in the durable power of attorney that you can initial, what you would have is a section in your trust called the trustee's powers. And you kind of see these in two forms depending on how simple the trust is. The trustee's powers could just be any power they have under Texas law. So Texas law has extensive statutes to say what trustees can and cannot do. Or you can sometimes see, here's our trustees' powers, and they'll list them out. And that list is usually there if you're wanting to change something that's under Texas law, or maybe elaborate on a little bit more, or you don't want your poor trustee to have to go dig out a statute book or consult an attorney to understand what they need to do. So your powers for your trustee or your agent are listed in the document. And it's usually, I guess, gives a little more guidance is the best way of putting it than your durable power of attorney. The second thing that's in there is how distributions are supposed to be made if the trustor is incapacitated, right? So these provisions are different from when the provisions that say when I'm dead, this is what will happen. These are the provisions that say when I no longer have the capacity to manage my affairs, this is what I want to happen. And so a little bit different from the power of attorney again, because you can make distributions to the trustor, the person who put money into the trust, but you can also ask your trustee to make provisions to, let's say, dependents. All right. So let's say you're a couple that has 2 children. One is an adult in their 30s, and the other has some disability that they still are at home and unable to really care for themselves. They're still dependent on you, although they're an adult. If your adult child who is not dependent on you is the trustee, you can set it up in your trust that if you're incapacitated, your trustee has to make distributions not only for your benefit, but for the benefit of that other child who is still dependent on you. Again, a little bit different from the durable power of attorney, because the durable power of attorney, you are supposed to be making those distributions for the principal. This allows you a little more leeway to say, no, I also want you making distributions maybe for a spouse or for a dependent, someone who is relying on me as well as for my benefit. Now, you can also say in the trust that you want just for your benefit, but it gives you a little more leeway and a little more flexibility. And then finally, in the trust, typically there is a definition of what is incapacity. And you, as the trustor, can change that definition, which is really quite helpful when you're talking about the scenario we talked about early on with the durable power of attorney, where child shows up to bank says, how do we know mom is disabled? And then you're kind of in this round robin of, I don't know, how do I give you proof? I don't even know what proof you're looking for, bank. This here spells it out. And so this provision that I've highlighted has the opinion of 2 physicians, right? So in this particular trust, for you to be considered incapacitated, whoever your trustee is would need to get 2 opinions from a physician. But there are lots of ways you could set this up. You could set it up as the opinion of the spouse alone. You can do it the opinion of the spouse with a physician. You could do 1 licensed physician. You could do a incapacity counsel in which you say, I want my 3 kids to determine whether they think I can continue acting in my best interest. And if 2 of them think I can't, then I want the incapacity provisions to kick in. So there are lots of ways that you can structure the incapacity to make it either flexible or onerous, depending on what you're trying to accomplish, which is a little bit different, again, than the durable power of attorney. So bringing this home, we have taken a lot of material on durable power of attorney and trusts, and I think it's helpful sometimes to try to put it into a chart, right, and simplify it and go, okay, what are each doing? I will tell you, if you have a trust, I still recommend durable powers of attorney. And those first 3 lines up there is why. If not all of your assets are in the trust, someone may need to handle financial matters for assets that are not titled in the trust's name. And if you don't have a durable power of attorney, that can kick off a guardianship for something that may not be very big, right? Maybe a small bank account, something like that. So you always, even if you have the trust, you still want the power of attorney as a backup, even if you're relying on your trust to do most of your aging or incapacity provisions for you. So 1, again, your durable power of attorney only manages assets and financial matters that are outside of the trust, and your trustee manages those assets that are in the trust. The trust can help you provide for dependents or spouses. The trust can give you standards for distribution. So what do I mean by that? Your trust can say, just give me all the income from my assets. I don't want you spending the principal on me, right? Or you can say all the income from my assets, but also the principal to the extent of my maintenance, education, and welfare, right? Or you can say, I want you, if I'm incapacitated, I want you to make distributions to my dependents for their education, but nothing else, right? So you can set up some standards on when the power of attorney should make distributions to who for what, which again is typically outside of something you'd see in a durable power of attorney. You also can put some standards in there for what does incapacity mean. Both you can put gifts in. You can get a little more specific in the trust on what you want those gifts to be. It's a little harder to do that in a durable power of attorney. The trust tends to be more flexible. You can add more provisions in, take it out, really modify it. And it's a little bit easier to use with institutions and across state lines. So once the assets are titled in the trust name, as long as the trustee is acting, it is actually easier to use than using a durable power of attorney. Now, the cost of a trust, it is more expensive. So it's more expensive to set up the trust initially. I don't know if it's really, the administration cost may be a little more expensive on the back end, but not much more if you're talking an incapacity situation for a DPOA. But a power of attorney tends to be a little less costly. And then finally, the power of attorney has some additional powers that you can put in there that you may not have in your trustee documents, right? So your trustee can't necessarily amend your trust or necessarily change your beneficiaries. They can just manage the assets that are in the trusts. So if you want someone to be able to have those additional powers, you do need the power of attorney. Again, those are, you know, those are special powers you really want to be careful of. That being said, the trust, you can build in what's called a trust protector and give them some of those powers. So the trust can do a little bit of that, but frankly, the power of attorney may be a little bit easier way of accomplishing those. So switching from those two biggies, those are really the two most comprehensive ways of establishing someone else's authority to help you as you age. The rest of these can help on more of a micro level, but they certainly aren't very comprehensive. So the first thing I do want to talk about is convenience accounts. That's what they're called under Texas statute. Sometimes these are called, you know, cosigner accounts, right? Or something like that. It's where you say, okay, I want someone else to be able to sign on my bank account on my behalf, right? However, I do not want them to be an owner in that account. So they don't get any ownership interest at all in the account. They can just sign checks. That's basically it. So, you know, someone who maybe has a lot of arthritis, right? And finds signing difficult, or someone who maybe has had a stroke and has some issues with writing, you know, these can be helpful. Or I have people just as they age will put convenient signers on their accounts. And again, it's helpful. They're relatively low risk, which is a good thing, but they only work for your bank accounts, right? These people can't manage your car or your real estate or anything else that may pop up. And these often aren't recognized by national institutions. So I have had some clients who have gone to national banks and tried to get these convenience accounts, and the banks just say no. They just don't offer it. Or they look at them like they're a little bit crazy. What? Convenience account? What are you talking about? So they're helpful if you're talking more of a Texas regional bank. But again, they are limited in scope, but they are also relatively low risk. Now, what you will see at national banks are sometimes, hey, well, why don't you put them on as a co-owner? I really am not a fan of co-ownership at all. If you watch the last presentation, you probably got that. And I'm going to repeat quickly some of why here as well, because I see this all the time. People, and sometimes what I see, people go in wanting to do a convenience account and walk out with a co-ownership account. And so that's problem number one. I think people sometimes don't really understand the type of account they're getting. And so the bank says, well, we don't do convenience accounts, but we can add them as a co-owner. And the person's like, sure, great. Can they sign on my behalf? Absolutely. But they don't understand the rest of the story, which I'm about to show you. So here are the risks of co-ownership. So here's my husband, Bob. Let's say I have met an untimely demise. And so he is aging and he decides to put our kids on the account with him as co-owners. Okay, so he's not just doing a convenience account. They don't just have signing authority. They come on as full co-owners. So what does that mean? That means they can do whatever the heck they want with the funds in that account. So let's say our son fell on hard times and lost his job. He could take money out of that account to live off of, right? Or let's say he has some other sort of judgment issue or problem. So he takes money out of that account to address it. Or even worse, let's say him or our daughter ends up with a judgment against them, right? So they've been in a lawsuit, they've lost, and they now owe someone money. Well, they can start looking at those accounts, even though that money may have been put in there by only my husband. It does start to create a situation where creditors and the people that they've been put on with them, so in this case, my son and daughter, can start reaching into those funds with relative ease and headache. So it creates risk, lots of risk. Unlike the convenience accounts, they're low risk. These are very high risk and have a lot of unintended consequences. Another unintended consequence is quickly, let's say my son gets married to that lovely lady there, and then he dies, leaving all of his assets to his wife. Well, his wife can now come back and say, hey, look, he had an ownership interest in this account. I think I'm entitled to funds in that account. Whether she get them or not is a discussion for another day and a lot of legal argument. However, just know it can create that situation where all of a sudden she thinks she has some rights in what is yours. So bottom line here is don't use co-ownership. Just use a trust or durable power of attorney or durable power of attorney instead. Or like I said, the convenience accounts are fine, but co-ownership just opens up a host of unintended issues that even if your kids are amazing, can create problems for you down the line. So enough about finances. Let's talk about medical matters. This will go a little quicker because these are really pretty straightforward and simple. Medical power of attorney, it authorizes a person to make medical decisions on your behalf if you are unable to. And again, in Texas, there is a form in which you name that agent who is going to be your power of attorney. And unlike the other powers of attorney, it only comes into existence if you are unable to make medical decisions on your own. So again, different from the financial power of attorney in that this only comes into existence if you're disabled. So really when this comes into play is you're in some way unconscious or unable to make known what you want to happen medically, and someone else is having to deal with your doctors. So usually it's emergent type of situations, although it may be other things as well. Again, we always recommend at least one alternate, if not two, because you never know if your first alternate might predecessor. I am so sorry. I think that kicked off for a second because we are at 11 o'clock. I'm sorry. I'm very talkative today, so I promise to make this a little quicker. So here we go. Let's share this, and we are almost done. One of the last things I want to talk to you about is medical directive. This is the living will or directive to physicians and family. And this, I often call it the Terry Schiavo document. She was a woman in Florida who ended up unable to manage her affairs because she had, I think it was a brain injury of some sort. Anyway, 15 years of fighting and court cases. And finally, she was allowed to pass. But that really kicked off the use of these documents. So basically, this is where you let your loved ones know if you want life-sustaining treatment, if you have a terminal illness that that cannot be cured. is ultimately what comes down to. Now, Texas breaks this into a terminal illness in which you're expected to die within 6 months, and then irreversible condition in which it may go on longer than 6 months. Something to definitely talk to, not only with your attorney, but your physician as well. Interestingly, people were very into these again after the Terry Schiavo incident, and then now with COVID, it seems less people are interested in these and willing to let their families make those decisions. It's, you know, very personal thing. We offer this to our clients, but it's definitely up to them if they want to use it. Do know that these definitions on the Texas form, they're on the back. It is worth making sure you understand those and that you are okay with them. So for example, life-sustaining treatment does include both artificial nutrition and hydration. So if you sign this, those things might be stopped. And so I don't know, yeah, some people feel okay with that, some people don't. It's really, again, something that I would make sure you're familiar with on that back page and that you're comfortable with. The last thing is the HIPAA release. HIPAA is the federal law that requires that your medical information stay confidential. Doctors, therapists are covered by this. And so you sign, every time you go to a doctor or a therapist, they have you sign this saying who they can give your medical information to. We often offer this as a document to our clients that's more generic, that says, hey, any of my medical information can be given to these people. It is intended to cover a situation where if you end up in a hospital or with a doctor that you've never seen before and you're in a state that you're unable to make your medical wishes known, your family can then see your medical information. So that's what the HIPAA release is for. Why does all of this matter? You know, we've talked a little bit about aging, but maybe you think, well, I'm never going to get to that point, right? I'm feeling fine. I don't really need this stuff. You know, life happens. If we all had the crystal ball, it'd be fantastic, but we don't. If you end up in a situation where you no longer have capacity and your family needs to get a guardianship for you, that is where they go. That means you cannot make medical or financial decisions on your own, and they need to be appointed as your guardian. And so they go to the court and say, we need to be appointed as guardian for either personal or financial decisions. It is costly, it is time consuming, and it is technically, legally technical, meaning you definitely want an attorney's help, which only raises the cost and the time consuming nature of it. Guardianships, if they can be avoided, are to be avoided. So again, guardianships are granted if you cannot make personal financial decisions on your own and you do not have a trust or power of attorney, or your trust or power of attorney are insufficient to cover the situation you're talking about. So sometimes you may want you may want a trust put in place, but your power of attorney doesn't allow your agent to create a trust, and that can then kick off a guardianship. So what, you know, when might a guardianship kick off? Because sometimes, even though people are aging and maybe have dementia, it's, you know, not a big deal because their family's sort of able to eke by. But here's the problem: if their affairs aren't set up and you need to handle something for them in terms of their finances and they lack capacity, they can no longer sign documents, and that will throw you into the guardianship proceeding. But there's also another instance. So sometimes people have a durable power of attorney so they can manage the financial affairs of their loved one, but their loved one may still think they have capacity and be signing stuff they shouldn't be signing. So sometimes you see people with dementia start to give away stuff or become the victims of elder abuse because they start signing stuff that they really shouldn't be. In those instances, if you have a trust, it's a lot easier to keep that from happening. If you don't, then even if you have a durable power of attorney, you may be looking at a guardianship. So I'm sorry to rush through those last things, but I appreciate you sticking with me. I will be stopping the recording here so we can take some questions.